If you believe in protecting the foundations of our legal and democratic systems, listen carefully to what I'm about to share. Take a moment to subscribe to the channel and switch on notifications because the developments that unfolded today in that Manhattan federal courtroom go much deeper than routine legal proceedings. They serve as a critical test of whether our form of government can still operate effectively when a powerful individual chooses to disregard the established rules. Here's the clear picture of events. This morning, just before noon, around 11:47, three top-tier, well-compensated defense lawyers rose from their positions at the counsel table, collected their documents, and began moving toward the exit while the judge was still in the process of speaking during an ongoing federal session. To make sure this registers fully, these are officers of the court bound by professional oath to support the Constitution, yet they attempted to leave their client without representation and walk away from active proceedings simply due to disagreement with the judge's decision. What came next stands out as exceptionally uncommon, something not witnessed in a federal courtroom for more than 20 years. I'll guide you through the events in order, because every detail holds real importance. The session started with ordinary procedural discussions, the kind seen in complex cases. Prosecutors pushed to introduce specific financial records. The defense objected. Nothing unusual at first glance for a matter of this scale. To grasp the full context, though, consider what occurred 48 hours earlier. A sealed document was mistakenly posted to Pacer, the federal court's online filing platform. It stayed public for precisely 17 minutes before correction. In that short interval, legal professionals downloaded copies. According to accounts from those who examined the material, the prosecution presented fresh evidence. Protected messages sent between Trump and his co-defendants in a period the defense had earlier insisted involved zero communication. The records reportedly showed transfers of $4.7 million, plus what one reviewer called perhaps the strongest documented evidence chain in any major financial crime prosecution. This morning, Judge Patricia Caldwell approved admission of the full 847 pages. That approval sparked the collapse. Lead counsel Robert Sterling stood and spoke, every phrase recorded by court stenographer Maria Rodriguez. He reportedly declared the court had dropped any claim to neutrality and that his team refused to take part in what resembled a foregone conclusion. Co-counsel Jennifer Matthews stated this represented extreme prosecutorial overreach and they would not validate it by staying seated. They then proceeded toward the door. Federal courts maintain strict protocols. Judge Caldwell, named to the bench by President Reagan, has served 31 years. She holds a widespread reputation for balanced, composed handling of cases. Many defense lawyers see her assignment as fortunate due to her even approach. Confronted with three attorneys trying to desert their client during trial, she issued words now in the permanent record. Counsel, one additional step toward the exit, and I will find you in criminal contempt, issuing immediate bench warrants for arrest. She directed U.S. Marshals to seal all doors. 6 armed marshals moved into place at every entrance almost instantly. The impasse continued for exactly 7 minutes and 23 seconds. If this information proves useful, please tap the like button now. The account grows considerably more intricate ahead. Judge Caldwell then shared details explaining the defense team's intense desire to depart. Reliable sources familiar with the session report she informed the court of receiving a sealed one-party submission from the Department of Justice earlier that day. For clarity on its significance, ex parte filings visible to only one side appear rarely in federal practice. They usually involve national security concerns or witness safety issues. On the record, she noted that, informed by this document, she weighed additional security steps and possibly sequestering the jury. Experienced defense lawyers across the nation grasped the meaning immediately. The government has a cooperating witness. An individual from Trump's close associates has switched sides. Andrew McCarthy, a former federal prosecutor, appeared on Fox News soon after, noting that a sealed ex parte filing in a case this size signals the situation tightening rapidly. An insider has cooperated, ready to deliver major unforeseen revelations. The evident distress becomes logical. Let's link these pieces because the narrative shifts from courtroom conflict to something with much wider impact. Court filings indicate that within 30 minutes of resuming seats post-standoff, Sterling's group submitted an urgent mistrial request, alleging judicial prejudice and prosecutorial wrongdoing. Concurrently, they sought Judge Caldwell's removal, claiming her arrest warning reflected personal bias against the defense. Observe the result. Staging this visible drama created potential bases for extensive appeals. Experts reviewing the matter agree universally. This performance targeted an audience outside the courtroom walls. Signs of coordination exist. Reports note Fox News positioned camera crews outside 45 minutes before the attempted exit. Certain conservative figures posted online about judicial overreach prior to public awareness of the event. How could they anticipate it? Subscribe if you'd like to stay informed on where this develops. The consequences reach deep. That sealed ex parte submission the judge referenced connects, per Department of Justice contacts, to testimony set for next Tuesday from a person listed in records solely as Witness 14. This individual purportedly holds first-hand details on the central financial activities in the prosecution's claims. The person has stayed in protective custody since October. The defense's bold exit attempt timed exactly 96 hours before that scheduled appearance. Pure chance? The alignment reveals much. Analysts debate Witness 14's identity. Prominent speculation centers on a key figure in Trump's financial operations, likely a chief financial officer or equivalent with immediate oversight of the disputed dealings. Protective custody starting in October points to legitimate safety risks. Such measures generally apply in organized crime or high-security contexts. If the witness provides the expected testimony, it could devastate the defense case. Following the resolution and attorney's return, Judge Caldwell made a statement that reverberated through legal circles. Given counsel's effort to abandon their client mid-proceeding, she is contemplating appointment of shadow counsel to protect the defendant's Sixth Amendment rights. Shadow counsel involves assigning standby lawyers at the defense table, prepared to assume control without delay if the primary team withdraws. Think of it as backup performers in a high-stakes production, though the outcome involves personal liberty and the broader credibility of American justice. Monetary fallout appears already. Federal Election Commission records show Sterling's firm has billed exceeding $12 million. Bloomberg reported late Friday that the firm began urgent discussions with its malpractice insurance provider. Contacts suggest the insurer fears exposure should the walkout contribute to mistrial or successful appeal. Field observers indicate policy jeopardy, possibly leaving partners personally accountable. That may explain senior partners arriving at Manhattan offices near 10 p.m. Friday for an apparent emergency strategy session. Like if you recognize the stakes extend past this single matter, today's occurrence endangers far more than one case. Allowing lawyers to depart proceedings whenever rulings disfavor them undermines the whole judicial framework. Judge Caldwell addressed it plainly, stating the court refuses to allow counsel to steer cases via intentional interruptions. Success in such methods would invite any anticipated loser to direct withdrawal and allege unfairness. U.S. legal history shows only 3 prior federal instances of defense counsel attempting mid-trial abandonment. In 1978, during Santo Traficante's mob case, Frank Rayano faced disbarment risks after trying to exit. In 1992's BCCI scandal, 2 lawyers sought to leave but continued under contempt threat. In 2009, Bernie Madoff's early team attempted withdrawal shortly into testimony but stayed compelled. Convictions resulted each time. Attorneys suffered major professional penalties. The trend stands obvious. Political responses arrived fast. Minutes after the attempt, Trump's Truth Social account posted that his lawyers fought bravely against a manipulated process, labeling the judge's arrest warning as election meddling. It gained over 2.3 million views in the first hour. Republican senators commented quickly. Tom Cotton tweeted that judges threatening arrest for client defense enters unstable territory. Elizabeth Warren responded that law applies equally, including to lawyers undermining proceedings. A Reuters Ipsos poll Friday evening showed 67% of Americans disapproved the walkout, with 48% of Republicans agreeing. 72% supported no one above the law, former presidents included. Even strong Trump legal backers hesitated. Alan Dershowitz told Newsmax that exiting mid-process before a federal judge lacks justification. Proper avenues exist for concerns. Client abandonment mid-trial is not one. When Dershowitz declines defense, a profound threshold has been breached. A lesser reported fact. An anonymous defense paralegal said Robert Sterling got a text at 11:42 a.m., 5 minutes prior, reading abort mission. The source ties it to a senior Republican advisor on messaging. If confirmed, the spectacle may have prioritized political effect over legal aims. Judge Caldwell seems aligned. Her Friday evening order included a notable section. The court suspects certain dramatic aspects stemmed from external coordination unrelated to impartial justice. Future efforts to turn proceedings into staged political displays will face all sanctions, including contempt, fines, and bar referrals. A federal judge has stated on record belief that today's events involved outside orchestrated political theater. Consider that carefully. Post-chaos, U.S. Marshals raised security to maximum. Extra detectors installed. All entrants underwent stricter checks. NYPD added perimeter units. FBI's New York office readied agents. This goes beyond normal. Afternoon session brought a security alert to the judge, prompting sidebar. Reports indicate it noted far-right militia-linked individuals near the building. No confirmed threat, but it intensified volatility. The judge warned both sides against inciting disorder, promising full federal enforcement response. Effects spread globally. European legal watchers expressed dismay. UK's ex-public prosecutions head said common law systems would mean instant detention. French coverage described U.S. justice in turmoil from Trump lawyers' defiance. Russian outlets portrayed it as U.S. institutional fragility proof. Lawyers feeling bold enough for this highlights eroding judicial respect with reach beyond the case. If still engaged, subscribe. The key revelation follows. Sources near Trump's circle report earnest talks on replacing the full legal group. Names mentioned include polarizing attorneys known for defending extreme cases like war crimes or terrorism suspects. Apparent approach: fight hard if defeat nears. This creates a near impossible spot for Judge Caldwell, allowing withdrawal risks, lengthy delays for new counsel preparation. Forcing continuation invites appeals on ineffective assistance grounds. A former Supreme Court clerk termed it shrewdly cynical. The defense crafted no-win choices for the judge. Prosecutors, sources say, consider a drastic move, revoking Trump's bail over counsel conduct, arguing such disruption signals flight risk and justice interference. Extreme and likely unsuccessful, but pursuing it would dominate news and perceptions. Reflect on the 12 jurors deciding the case. Absent during the exit, afternoon strain showed clearly. Juror 7, retired Brooklyn teacher, shook her head often at defense points. Juror 3, small business owner, noted extensively when judge spoke to counsel. Jury expert Dr. Patricia Williams told CNN such judge-defense clashes often signal guilt awareness to jurors. Why risk careers otherwise unless evidence burdens the client heavily? Defense scored procedural points today, but jury trust may suffer lasting harm. Monday, Judge Caldwell rules on mistrial and recusal motions. She decides witness 14's schedule. Repeat disruption means immediate arrest, she stated. Marshals briefed on attorney detention procedures, unprecedented in recent federal memory, sources note. Timing matters, 11 months to 2024 election. Trial days limit Trump's campaign attention. Analysts suggest walkout aimed at mistrial to delay past election. A risky tactic viewing court as political ground. Judge Caldwell seems set against it. Those knowing her view say 6-day weeks possible to stay on schedule. Media limits considered if coverage fuels drama. Today's events transcended legal tactics, an effort to recast courtrooms as political stages. When lawyers believe they can exit federal judges unpunished, defendants treat trials as campaign tools. Justice merges with spectacle. Our constitutional design faces strain it may not withstand. Even Republicans distance now. Mitt Romney stated judicial respect underpins democracy. Zealous representation matters, but fleeing federal court exceeds bounds. Josh Hawley, usual Trump ally, stressed proper procedures when asked. Losing Hawley type signals core strategy flaws. True harm surpasses verdict. Citizens deserve skilled counsel and fair process under rules. When rules falter, lawyers fleeing adverse rulings, it shows system bendable by wealth and daring. Not justice. Disorder in formal dress, hourly billed. Consequences surpass one case or person. If successful, wealthy defendants nationwide may mimic. Envision trials where resourceful parties direct exits on bad rulings, proceedings as social media art over truth-seeking, judges threatening arrest for order. No justice system then. Rule of law ends as principle. Now, can Judge Caldwell regain control? Will defense persist? Can courts endure this core challenge? Subscribe with notifications. This continues. When Witness 14 testifies, mistrial ruled, abort text source revealed. Stay tuned. Like, comment your prediction, share with those concerned for democracy. Beyond one trial or defendant, do we uphold no one, wealthy, powerful, connected, above law?